In a different case, I had the opportunity to address a group of appraisers. There were 55 certified and licensed appraisers, and I asked them to identify the 6 quality ratings in the Marshall & Swift Residential Cost Guide. They provided 18 unique answers from 55 appraisers. 34 of 55 included average as a quality rating, which it is, and only 4 of 55 correctly identified low. And so the point here is that there were, again, a lot of interpretations from a small group of appraisers who realistically understand what they're doing. They were seasoned people. Again, this same group was asked to identify the 6 condition ratings in the Marshall & Swift. We got 20 unique responses. 34 of 55 did include average as a rating, and only 16 identified poor correctly as a condition rating. So when we take a look at the term average, the Marshall & Swift Cost Guide does define average as it relates to maintenance, obsolescence, things to do with the condition of a property. But for every other definition of average, it relates to mathematics, central tendency, mean, median, mode, so forth. And so I think we need to recognize that this term, especially as it's so broadly applied throughout the appraisal reporting process, doesn't lead a reader to very much understanding of what the appraiser is ultimately trying to convey. And so now at this point, I'm going to turn the presentation over to Peter Christensen, who will give us a little bit of a view from the liability perspective.
The appraisal issues that Bill spoke about that prompted the GSEs to create the UAD and also the Uniform Collateral Data Portal really have a direct tie-in to liability issues affecting both appraisers and AMCs, and also even to a larger extent their clients, mainly lenders. So we're going to look at some sources of claims to see where these issues fit in, and then later we'll discuss how we think liability issues will be affected by UAD and also the UCDP. So since the mortgage crisis, and I pin that at about 2007, more than 50% of the claims against both appraisers and AMCs have come from borrowers. Now, the biggest claim that borrowers have filed is usually overvaluation, and basically there the story is always the same, whether it's in a lawsuit or a demand letter or a board complaint, and that story is from the borrower, I borrowed too much. Then there are many other claims that are about a failure to identify or disclose a property issue affecting a property in an appraisal report. So the borrower here could be saying, my roof leaks or the property floods. And then lastly, we're starting to see some claims from borrowers about undervaluation. And there the story from the borrower in a lawsuit or in a complaint to a state board is usually, I can't get the refinancing I want yet again because the appraisal is now too low. Now lenders, they account for about 40% of the claims that we see against appraisers and AMCs. The thing about lender claims is monetarily they do result in a greater total amount of damages to AMCs and appraisers being paid out. And here the predominant claims are overvaluation. There the lender's saying we lent too much money basically in most of these cases. And then a large segment of the cases do relate to appraisal compliance problems. And the main issue here are forced repurchases from the GSEs, forced repurchases of mortgage loans in default, I should say, from the GSEs and from other mortgage investors. And so the claim basically here would be from a lender who's been forced to repurchase a mortgage, would be Fannie Mae demanded that we repurchase a foreclosed mortgage because of an appraisal issue. This last one here is a key to the issues that we're talking about today and really has the most direct relationship to UAD and UCDP, although all the other types of claims you see here from borrowers and lenders do have a relationship. Basically, the GSE forced repurchase issue is a gigantic liability issue for lenders, and that liability trickles down to AMCs and appraisers. Now, just to round out who the sources of the other claims are against appraisers and AMCs, I can point out that the FDIC is the single biggest source right now of lawsuits against appraisers and demand letters. And then we also see some claims from sellers and other parties like agents, brokers, even UPS delivery men. But we don't expect those types of claims to be affected by what we're talking about here today. So the need for UAD is really suggested by the typical liability claims we see from the borrower and lender sources, because the reality is that the reports that are the subject of claims are overwhelmingly the types of reports that the UAD is aimed at fixing. Reports which use meaningless form-filling language such as the word average too often. So to look at the specifics of how one of these repurchase cases evolves and how this might be changed in the future, I'm going to walk you through an actual Fannie Mae repurchase situation and the lawsuit that sprang from that repurchase. So here in front of you is a repurchase demand sent by Fannie Mae to a lender. Tens of thousands of these repurchase demands are being sent every year to lenders that originated loans that were then sold to Fannie Mae. Now, these claims arise because lenders, of course, as Bill said, are required to represent and warrant that the appraisal for the mortgages they're selling to Fannie Mae met standards in Fannie Mae's selling guide or met various appraisal standards, including USPAP. But there's been no checking of the appraisal pre-funding until this point. And Fannie Mae or Freddie Mac has exclusively relied on the originating lender's representations and warranties as to the quality of the appraisal. So when a default or foreclosure occurs and there's an appraisal problem, it's only years later that that surfaces, and at that point, Fannie Mae forces a repurchase. So here in this particular letter, you can see that the date of the notification is in July of 2009, and it's for a repurchase of a loan. And down here, Fannie Mae sets out why this lender here is receiving this repurchase demand from Fannie Mae, and that's because almost 2 years earlier, in December 2007, this lender delivered an appraisal that did not meet Fannie Mae's selling guide with respect to appraisal quality. And in front of you now is the actual loss mitigation statement that Fannie Mae sent to this lender because of this mortgage repurchase. And you can see that the lender here is now being required about 2 years later to pay Fannie Mae $185,000 for the loss associated with this appraisal defect in the appraisal that was appraisal for the mortgage that was sold to Fannie Mae. So at this point, the lender here, who's suffered this loss because of the appraisal defect, has several choices. They can eat the loss, or if it's an AMC ordered appraisal, they can go after the AMC under the representations and warranties that the AMC typically makes in their contract with the lender. Or the lender can go straight to the appraiser and sue the appraiser. And that's what occurred here. What you see in front of you now is our actual paragraphs from the complaint that this lender filed in a state court within the last month. And in this case, the lender is suing the appraiser. And I'll just quickly show you some of the allegations here. And the lender here says that in December 2007, this bank made a $405,000 loan to the borrower, Roger, and it was a property in California. And then Bakel was the mortgage broker here. The mortgage broker chose defendant Robert as the appraiser on this property, and he appraised the property at $540,000. And then the bank here alleges that based on that appraisal, the bank funded the loan and subsequently sold that loan to Fannie Mae. And then in July 2009, as I showed you earlier on that repurchase demand, Fannie Mae demanded that the lender repurchase the loan to this borrower because of Robert the appraiser's negligent or deficient appraisal.